A decree is a rule of law usually issued by a head of state, according to certain procedures. It has the force of law. The particular term used for this concept may vary from country to country. The executive orders made by the President of the United States, for example, are decrees. In non-legal English usage, however, the term refers to any authoritarian decision. Decree by jurisdiction. Belgium. In Belgium, a decree is a law of a community or regional parliament, e.g., the Flemish Parliament. France. See Government of France. The word décret, literally decree, is an old legal usage in France and is used to refer to orders issued by the French president or prime minister. Any such order must not violate the French constitution or code of law of France, and a party has the right to request an order be nullified in the French Council of State. Orders must be ratified by Parliament before they can be modified into legislative acts. Special orders known as décret loi, literally decree act or decree law, usually considered an illegal practice under the Third and Fourth Republic, were finally abolished and replaced by the ordinances under the 1958 Constitution. Except for the reserved powers of the President, the executive can issue decrees in areas that the Constitution grants as the responsibility of Parliament only if a law authorizes it to do so. In other cases, orders are illegal and, should anyone sue for the order's nullification, it would be voided by the Council of State. There exists a procedure for the Prime Minister to issue ordinances in such areas, but this procedure requires Parliament's express consent. Orders issued by the Prime Minister take two forms, or orders. Orders in Council, when a statute mandates the advisory consultation of the Conseil d'État. Sometimes people refer to décrets en Conseil d'État improperly as décrets du Conseil d'État. This would imply that it is the Conseil d'État that takes the decree, whereas the power of decreeing is restricted to the President or Prime Minister. The role of the administrative sections of the Conseil is purely advisory. Decrees may be classified into regulations, which may be application decrees, each of which must be specifically authorized by one or more statutes to determine some implementation conditions of this or these statutes. These constitute secondary legislation and are roughly equivalent to British statutory instruments. Autonomous regulations, which may be taken only in areas where the Constitution of France does not impose statute law. These constitute primary legislation. Particular measures, such as the nomination of high-level civil servants. Only the Prime Minister may issue regulatory or application decrees. Presidential decrees are generally nominations or exceptional measures where law mandates a presidential decree, such as the dissolution of the French National Assembly and the calling of new legislative elections. Decrees are published in the Journal officiel de la République française or French Gazette. Catholic Church. A decree in the usage of the canon law of the Catholic Church. It has various meanings. Any papal bull, brief, or motu proprio is a decree inasmuch as these documents are legislative acts of the Pope. In this sense the term is quite ancient. The Roman congregations were formally empowered to issue decrees in matters which come under the particular jurisdiction, but were forbidden from continuing to do so under Pope Benedict XV in 1917. Each ecclesiastical province, and also each diocese may issue decrees in the periodical synods within the sphere of authority. Canon 29 of the 1983 Code of Canon Law offers a definition of general decrees. General decrees by which a competent legislator makes common provisions for a community capable of receiving a law, are true laws and are regulated by the provisions of the canons on law. laws. Holy See. The Holy See uses decrees from the Pope such as papal bull, papal brief or motu proprio as legislative acts. Italy. According to Clause 77 of the Italian Constitution, the government may not, without an enabling act from the Houses, issue decrees having the force of ordinary law. When in extraordinary cases of necessity and urgency the government adopts provisional measures having the force of law, it must on the same day present said measures for confirmation to the Houses, which, even if dissolved, shall be summoned especially for this purpose and shall convene within 5 days. The decrees lose effect from their inception if they are not confirmed within 60 days from the publication. The Houses may, however, regulate by law legal relationships arising out of not confirmed decrees. The effectiveness for 60 days produces the effects immediately, giving rights or expectations whose legal basis was in fact precarious, especially when the conversion law never intervened. Portugal. In Portugal, there are several types of decrees issued by the various bodies of sovereignty or by the bodies of self-government of autonomous regions. Currently, there are the following types of decrees. Decree law is a legislative act issued by the government of Portugal under its legislative powers defined by Article 198 of the Portuguese Constitution. Regional legislative decree is a regional law issued by the Legislative Assembly of an autonomous region, within its powers defined by Articles 227 and 233 of the Constitution. Decree of the President of the Republic is a decree issued by the President of Portugal for the ratification of international treaties, the appointment or dismissal of members of the government or to exercise other presidential powers defined in the Constitution. Decree is an act issued by the government of Portugal to approve international agreement whose approval is not within the competence of the Assembly of the Republic or has not been submitted to it or within the government administrative jurisdiction laid down in Article 199 of the Constitution in relation to a statute that requires this decree. Regulatory decree is an act issued by the government of Portugal under its administrative jurisdiction laid down in Article 199 of the Constitution, to make the necessary regulations for the proper execution of the laws and to take all actions and decisions necessary to promote economic and social development and to meet the community needs. Regional regulatory decree is an act issued by the legislature or the government of an autonomous region, regulating the proper implementation of regional legislative decrees. Decree from the representative of the Republic is decree of appointment or removal of members of the government of an autonomous region, issued by the representative of the Republic for that region. Iran. According to the Article 110 of the Constitution, the Supreme Leader delineates the general policies of the Islamic Republic. Russia. After the Russian Revolution, a government proclamation of wide meaning was called a decree. More specific proclamations were called ukaz. Both terms are usually translated as decree. According to the Russian Federation's 1993 constitution, an ukaz is a presidential decree. Such ukazes have the power of laws but may not alter the Russian constitution of the regulations of existing laws, and may be superseded by laws passed by the Federal Assembly. The government of Russia can also issue decrees formally called decisions or orders and may not contradict the constitution. Laws are presidential decrees. United States. In U.S. legal usage during the 19th and early 20th centuries, a decree was an order of a court of equity determining the rights of the parties to a suit, according to equity and good conscience. Since the 1938 procedural merger of law and equity in the federal courts under the Federal Rules of Civil Procedure, the term judgment has generally replaced decree. This is now true also in most state courts. The term decree has had a similar usage in admiralty, probate, and divorce law. A decree is often a final determination, but there are also interlocutory decrees. A final decree fully and finally disposes of the whole litigation, determining all questions raised by the case, and it leaves nothing that requires further judicial action. It is also appealable. An interlocutory decree is a provisional, a preliminary decree that is not final and does not fully determine the suit, so that some further proceedings are required before entry of a final decree. It is usually not appealable, although preliminary injunctions by federal courts are appealable even though interlocutory. Other uses of the term. In some jurisdictions, certain types of court orders by judges are referred to as decrees, e.g., a divorce decree.